Hey patent friends, so in this video I'm going to give you my insider tips on how to pick the patent attorney that is right for you, for your product, for your business, for your budget. So the first thing I want to get out of the way is, so yes, I'm a patent attorney, and you might think, okay, this is going to be really biased. You're just going to give me information about how to pick you as a patent attorney. So let me just give you this disclaimer. I will not work with you if you contact me about this video. You'll note that I'm not putting my phone number, I'm not putting my email on this video. I'm not looking to get your business out of this. This is the advice that I would give to a friend or family member if for some reason I wasn't able to represent them. If I had to give them advice on how to pick a patent attorney, this is the advice that I would be giving. The first thing to understand is that not every patent attorney is going to be right for you. And this is going to be based on what sort of company you have, what sort of product you have. Okay, so a lot of patent attorneys will only work with certain types of companies. Maybe they only work with large companies, or they only work with startups, or they only work with small companies with consumer products. You want to find somebody who understands your product and your business model. And a great example here is that people look for patent attorneys who work with big companies like Amazon or Microsoft and say, hey, I want to work with them because they must know what they're doing. They're going to be really great working with me as well. But that is not the case. The way that you build a patent portfolio for a startup or for a small consumer product is completely different than the way you build patent portfolios for large companies like Amazon and Microsoft. And so trying to find people who have that experience, you're actually probably going to get worse service, and it's going to be way too expensive compared to the way it should be. And you're going to get value out of your patent portfolio that is probably going to be a lot less just because the people don't have that experience. Okay, so some people, they're just not interested in working with certain types of clients. People, who work with the big companies, a lot of times they're not really excited about working with startups or individuals. Okay, that's one of the first things you want to do is ask them, hey, do you have experience working with startups or companies that are like me, or with products that I have? And are you even interested in working with folks like me? That's one of the most important things to realize, is that not every patent attorney is going to be right for you. And honestly, not every patent attorney is going to want to work with you. Another critical thing to understand is that only registered patent attorneys or patent agents can actually represent you before the United States Patent and Trademark Office. And I'll leave a link down below that can make sure that the person that you're talking to is actually a registered patent attorney or agent. If not, they don't have the ability to represent you before the United States Patent and Trademark Office. And I've seen this where, a lot of times it's well-meaning attorneys or other folks say, oh yeah, I'll be able to represent you, not realizing that they're actually not authorized. So to be a patent attorney, you have to understand the technology of your clients as well, if not better than them. And you have to take a separate bar called the patent bar. And to sit for that patent bar, you have to show that you have a technical background. So for me, as a patent attorney, I have a master's in electrical engineering. I have an undergraduate degree in biochemistry and molecular biology. And that ticks the box to allow me to sit for the patent bar, which allowed me to become a patent attorney. That's the first thing. So make sure that who you're actually talking to is a patent attorney or a patent agent, and confirm that at the USPTO website. Also, there are people who may have become patent attorneys, but maybe they don't really practice with the preparing patent applications, planning patent portfolios, and working them through the examination process. And my suggestion would be is to ask people, or look for a focus of spending at least 90% of their time drafting patent applications, planning patent portfolios, and working them through the examination process. It is a very, very specialized practice. And honestly, there are people who I know who are patent litigators who have a registration number because they have a technical background and took the patent bar, or people who are trademark attorneys who, instead of getting the patents, focus on trademarks. And yes, while technically they can represent you before the United States Patent and Trademark Office because they took the patent bar and have a registration number, does not mean that that is the person that you want to be working with. You want a person who is a patent attorney who is doing 90% or more of their job in planning patent portfolios, drafting patent applications, and working them through the examination process. That is extremely important. It's one of these things where somebody who is sort of jack of all trades and does everything isn't going to be best for you. Yes, technically they'll be able to help you, but you need somebody who has a lot of experience. Those are the people who really are going to bring a lot of value to the table and get you the best advice on planning your patent strategy and then executing that with the patent application and then through the examination process. The next important thing is to find somebody who has experience with businesses like yours. And again, somebody who all they do is big companies like Amazon and Microsoft. They're not going to have the experience to really give good advice to startups or to individual folks with consumer products. They just don't have that experience. So make sure that people understand the business type. That's probably the next most important thing to be thinking about. Along with that is you want somebody who is excited to work with you. Sometimes patent attorneys are really busy. Maybe they're on the end of their career, or they're just busy with their existing clients. Find somebody who is going to be excited to work with you. That's a valid question to ask people. Say, hey, do you have the time? Are you excited to work on this sort of stuff? Another thing is that, so because patent attorneys have to have a technical background and they have to be able to understand the inventions of their clients as well, if not better than them, you want somebody who has a technical background and ideally experience with patents that are going to be similar to your technology. Now, there are two main areas that patent attorneys tend to practice in. They're going to practice in the biotech space, which is very different than things like computers. It's a very different sort of practice. So even though I have an undergrad degree in biochemistry and molecular biology, when it really comes down to it, I work with specialized attorneys who their practice is just on doing biotech and chemistry and things like that. Yes, I understand the technology, but a lot of my work is in computers, which is a very, very different sort of practice. So that's why I have a lot of team members who I work with them and I have them focus on drafting the applications, because how you do that is very, very different than the computer stuff. On the other hand, with computers, that's the bread and butter of what I do. That's what I understand the most. That's what I have my electrical engineering degree for. And so, for those clients, I totally understand that. So those are the two main areas that people are going to be working in. There can be a lot of overlap with mechanical devices. So a lot of times any sort of patent attorney can learn how to do things with mechanical devices, but at the same time, if that's sort of technology that you have, if you have consumer products or things that are physical products, make sure that the patent attorney understands how to do that. So for instance, I know a lot of patent attorneys, all they do is software, but when they try to do patent application on physical things, they don't do a very good job, because the way you do things that are software that are very abstract don't really apply a lot of times doing physical things. So if you have a physical product, make sure your patent attorney has experience with doing physical product sort of stuff. Similar with the biotech folks, yes, they may have experience doing things like medical devices or stuff like that. They may totally know how to do mechanical things, but just make sure that they understand that stuff. Ask them how much experience they have with mechanical devices. Another consideration, unfortunately, is budget. There are some patent attorneys who have extremely high rates and they're used to working with really highly capitalized clients and may not really be structured to work with smaller companies that don't have as much money. That may be a reason to pick one patent attorney over the other if they don't have the relevant experience working with smaller clients. They just may not be set up to work with startups or to work with people who have commercial consumer products that are kind of smaller. They may just be set up to work with these big Fortune 100 companies and really don't have a structure that allows them to be cost effective for smaller clients. So always keep that in mind as well. Make sure that it's somebody who can work within your budget. Now, as important as it is to find certain things in a patent attorney, there are other things that really aren't that big of a deal, surprisingly. One is billable hour. There are some folks who have extremely high billable rates, but they're going to be a great fit for you because they're going to be more efficient, they have better experience, and overall, even though their billable hour rate is a lot higher, they're going to be able to get you higher quality in less time, and so the overall cost is going to be a lot less, and you're going to be able to get higher quality patent assets that are tailored to your business. So in terms of billable hour, don't always look at that. Sometimes high billable hour, assuming they're a right fit for the other reasons that I talked about, that can be totally fine. And sometimes it's very counterintuitive. There may be attorneys who have a really low billing rate, but in the end, they're going to cost you way more because they don't have the relevant experience, and it's going to, they're not going to give you great advice. And so it may seem like, well, I should go with the person with the lower billable rate. That's definitely not always the case. Another thing is geographic location. So Luckily with patent attorneys, we have federal jurisdiction. Patents are a federal type of law. So we can work with clients throughout the country and literally worldwide. If anyone is coming to get a United States patent, we can work with them. I have clients all over the country. I'm based in Seattle, but honestly, a lot of my clients are based in the San Francisco Bay Area. I have clients in most states, and I have clients in a lot of different countries, especially in Europe. So don't really feel like you need to find somebody that is in your town or in your state. If somebody is a good fit and you're comfortable working remotely with somebody, feel free to work with a patent attorney that is not in your town or even not in your state. That's totally fine. Another thing is specific technology experience. And like I said, you want to find somebody who has general experience with the type of technology that you have, but it doesn't need to be laser focused. And this is something that I see with some folks who are searching around for the perfect patent attorney, is that you're probably not going to be able to find that one person who all they do is work on these things. A great way to think about it is, so again, you have biotech. Find somebody who is in the sciences with chemistry, biotech, if that's what your technology is. Find somebody who works with computers. That's another section. There may be some focus with software versus hardware or the combination of both, but really anyone who deals with computers is typically going to be able to deal with any sort of computer technology. But then also physical products. Make sure that people understand how to actually work with physical products. That's something that's really important. But again, don't feel like it has to be somebody who works only with your specific technology. That's really unnecessary. Another thing that surprisingly doesn't make as big of a difference as you would think is the size of the firm. So there are big firms that can have hundreds of attorneys, kind of like the firm that I'm at. We have over 600 attorneys in our firm. There are boutique firms which can, be tens, if maybe 50 something attorneys, and there can be solo practitioners. Now, sometimes people, for instance, think, oh, well, solo practitioners, they're not going to be as good. They don't have as much experience, or I need a big firm because, they have certain infrastructure, they have a name. And while that can be important, for instance, sometimes it's important for investors to have a big name associated with your legal stuff so they trust in the work that's being done. Realize that there are going to be great people at individual solo practitioner firms, at boutique firms, and at large firms who are going to be able to do a great job for you. It's the other issues that you should really be considering and not necessarily the size of the firm. All right, so here are some insider bonus tips that I want to give you about picking a patent attorney that really only patent attorneys are going to kind of know about. One is to find somebody ideally who is excited to work with you but isn't desperate to work with you. A lot of times people who are desperate to work with folks and need to bring on a lot of clients, they may not always have your best interest in mind. They kind of need the money, and so they may not do the things that are best for the company. Look for somebody who, again, is excited to work with you. Some people, they don't work with clients like you. They don't want to take on additional clients. Find somebody who's excited about what your business is, what your product is, and is willing to make the time, but isn't desperate, okay? Another thing is, you should consider the patent attorney to be a trusted member of your team. The folks who aren't very successful when working with legal counsel, and especially with their patent attorneys, where they say, look, I'm just going to direct you what to do. I'm going to give you marching orders. That is not a great way to work with patent attorneys. It should be a collaborative thing. You should be going to them to say, hey, here is what my business is doing. Here is my technology. What are your suggestions for how to build a patent portfolio? When should we file the patent applications? How much should we budget for these things? It should ideally be a trusted member of your team, even if this person is at an outside firm. And if you can't trust that this person has your best interest in mind, you should find somebody who you can trust. That's the way that you should go about it when you're hiring this person. Hire them like you're hiring a strategic member of your team, because a good patent attorney can totally make your company and add tons of value and is going to be a huge asset to the company long term. These are long-term relationships that you're going to be building. It's not just somebody who files a patent application. So a lot of times, for instance, like you file a provisional application that lasts for a year, then you have to file the non-provisional a year later. Then there's the examination process 1 to 3 years later. After that, you're filing multiple applications. I mean, a lot of times this is going to be a multi-year relationship. So you want to have somebody who's going to be a trusted team member. Also, So be sure you understand the steps of the patent process and the general costs that are going to be associated with that. Now, a lot of times patent attorneys are well-meaning, but they understand patents so well that they sort of forget that most people don't understand the patent process and don't understand the costs associated with that. And it's difficult sometimes where people, for instance, they say, oh, well, we filed this patent application, I should have an issued patent and there's no more cost with that. So that's not the case, right? And this is one of the biggest disconnects that I see, is that people file the expensive non-provisional like, okay, now we're pretty much done. Now it's going to be rubber stamped and we're good. They don't realize that, okay, well, one, it's going to take 1 to 3 years before examinations is going to begin. And then there's going to be a back and forth with the examiner. There are going to be rejections. You're going to have additional cost. It's like Pawn Stars or American Pickers, where you should anticipate there to be a negotiation. That's how you get the broadest patent protection possible, is through this negotiation. And sometimes patent attorneys honestly aren't great about talking about these things, saying, hey, we filed your non-provisional patent application. It's going to be 1 to 3 years before examination begins, and there's going to be additional costs in this examination process. Sometimes it's easy and inexpensive. Sometimes it's really difficult and it's going to be really expensive, right? And I've, early on in my career, honestly, when I kind of just sort of figured that everybody knew about this, it would come to the examination and say, oh, your patent application got totally rejected, and now we're gonna have to respond. And people are like, what do you mean? What are you talking about? We never heard about this. I was like, well, but you knew that, right? No, people don't understand these things. So understand all the aspects of the patent process, understand provisional versus non-provisional, and ask your patent attorney these questions. Ask them to explain the basics of the patent process and generally what the costs, are going to be at each of these stages. A lot of times it's not, you can't really know, especially in examination. Sometimes you get an examiner who's gonna, rubber stamp your application. You don't really have to pay much additional money to go through the examination process and get it issued. Other times you have an examiner who's new or doesn't understand the technology, or there's a lot of prior art related to what your technology is, and you have to battle it out for years and years and years, and it's going to be expensive. So make sure you understand those costs before you jump into things. So before I give you the final insider tip that may be one of the most important ones, if you're getting some value out of this video, please give it a thumbs up, help it get out to more people, and consider even sharing it maybe on LinkedIn or something. Okay, so the final piece of advice that I think is pretty critical in a lot of ways is that cheap is not always better. A lot of times people want to do things as inexpensively as possible, or they find these cut rate firms that have super low billable rates, or a lot of times even flat rates, and they think, okay, I'm going to be able to get a really good deal here. They have low cost, maybe it's flat fee, they have low billable rates. But honestly, in a lot of ways, I see folks who do stuff on the cheap getting worse advice. In the end, they end up spending way more money. A lot of times they're not going to actually get issued patents out of things. The attorneys, that work on super flat rates, sometimes I've seen it where they almost intentionally drag out the process and sort of, it's like death by 1,000 cuts. The examination process takes way too long, and what, costs double what it should have cost had you work with somebody who had a higher billing rate. So don't always think about the cost of, say, like flat rate or billable rate or things like that. That can be one of the things that really messes people up. They end up getting really poor advice. It doesn't really serve the company very well, and in the long run results in people being non-successful. So thanks for watching, and we'll see you again in the next video. Thanks.